matter of Ideal Shopping Direct Ltd and others, and VISA Europe Ltd and others. Part heard.
Yes, my lords, my lady. I was just moving on to the case of the Serbian Orthodox Church and Kesar behind tab 20 in the authorities bundle.
That's the decision was Justice Fox.
It is indeed, sir. Yes. And this was a case where the defendant applied to set aside a default cost certificate on the basis that the notice of commencement had been sent to the wrong email address. So in this case, valid and timely notice existed, but it hadn't been sent to the agreed email. But it was accepted that the email was forwarded automatically to the agreed.
It's a very odd case, isn't it?
It is complicated.
He decides that it wasn't good service. Is that right?
That's right, but the
It wasn't sent to the right email address.
Indeed. So if you see that, you see the paragraph 8 on page 406. The senior master finds a little 2. He agrees with the defendant that the email, sending the email to the long form email address, which was not the agreed one, but that notwithstanding that it had been sent automatically instantly to the correct email address, wasn't valid service, and that was appealed that was defective service for which the appellant sought correction under CPR 310 or CPR 6.27, and that's on page 407.
Yeah.
And for the court, CPR 6.27 is the equivalent of 6.15.
For other documents.
Indeed. And you get that from the middle of page 408. The particular facts aren't really important for my purposes. This is just a good summary of the authorities.
Yes.
And they were considered in full by Mr. Justice Foxton, including Boxwood, which you see referenced at page 421 on paragraph 50. And then it culminates in his summary on page 422, conclusion as to the proper approach, paragraph 51. And he says, I must confess to having some difficulty with the suggestion that CPR 310 could be relied on to validate a defect in service where, for example, service had been effected by email without permission to serve at that email address, in any case in which relief could not have been obtained under CPR 6.15. He makes this point, which we haven't discussed so far. A particular difficulty with 310 is that if it is applicable to service errors, CPR 310A would appear automatically to validate service unless the court ordered otherwise. That, with respect, is a surprising proposition and an approach which requires the party seeking to validate service to seek and obtain an order from the court seems inherently more appropriate. Further, the reasoning which commended itself to Nicklin J. and Morgan J. that 310 is as a provision of general application must yield to the more specific provisions on service in, for example, CPR 615, 627, and CPR 7.63 also commends itself to me for conventional legal reasons and because it has strong support from the majority of the Supreme Court in Barton when addressing a similar argument as to the interrelationship of CPR 3.9 and CPR 615. So that's all I need from that case.
Yeah.
And I move on then to City Sprint.
So conventional approach, you would say, does he doesn't actually refer to Vinos, does he? I can't remember that. He just refers to the first instance of that.
No, he does refer to Vinos. In his summary of the authorities, so paragraph 421, he quotes Boxwood, and he refers to the summary of the law in Boxwood,
I've got
which
you,
includes
sorry.
Vinos.
It's through this case and Boxwood, yes. Yes, I follow. Yes. Thank you.
And
do we need to look at Barton?
for this purpose, no. Well, Barton isn't a 310 case.
It isn't a 310 case,
No.
but the principle that the general rule has to cede to the specific
It's not stated in the clearest of terms. I mean,
No.
I'll show you the relevant part of Barton when I come to discretion.
Yeah, okay.
But
That's fine.
It's there, but
Yeah.
it's not as clear as it
Not as
is
clearly
in
as
Venus
it
and Steve.
Okay, so now we're looking at City Sprint.
City Sprint. Now, I shan't linger on this because you've been through it in detail with our friends. The solution, as the court has already seen in City Sprint, is in paragraph 53, page 471. And here, Ms. Justice Fraser agrees with the submission made by the applicant and explains that it's an attractive argument for these reasons. The timing makes it clear the sealed claim form was already in existence when the unsealed copy was sent. The sealed claim form was simply not available to download on the 27th, the relevant day, when it had been issued. That's because of the outstanding payment. Proceedings had, however, clearly been commenced by then because the claim form had been issued and the seal had been applied. Now,
With respect to the judge, that's just wrong.
that's my first point.
This is wrong.
What's wrong?
As I said to Ms. Smith yesterday, the whole point, if you read the practice direction, it's absolutely clear. It's only at the moment of acceptance of the claim form that the court staff seal it. So before it's accepted, so on the 27th of July, whatever the date was, 27th of July, there wasn't a sealed claim form in existence.
No. That's my first point, my lord. I'll move on. My second point is that in any event, in this case, there was no sealed amended claim form in existence by the end of the 17th of July 2020. And my third point, and most importantly of all, is that the approach in this judgment is inconsistent with the principle in Venus that 310 cannot be used to cure defective service in cases where doing so would circumvent other provisions, other specific provisions in the CPR. And we see that most clearly in paragraph 60 and 61. And this goes to the point that my Lord Justice Birss made when he asked what was the judge actually asked to do. And we see that in the last sentence in paragraph 60. And the learned judge says, I'm simply making an order that service of the unsealed claim form on the 27th of July should count as though it were service of the sealed version of the exact same document. But that, my lords, my lady, is CPR 615. That is, in substance, very clearly, an order to permit service by an alternative method. And he goes on at paragraph 61 to say it's not necessary to consider alternative service under CPR 615. But he goes on to say at 62, had he applied CPR 615, he would have found in favour of the claimant also. But that, with respect, is the wrong approach. Because if in substance what is sought is service by an alternative method, this specific rule, 615, ought to be applied, not 310. And there was no consideration, of course, of the Court of Appeal in Venus, or Steele and Mooney, or Elms, and no consideration of the principle of statutory construction which underpins those authorities. So, in our submission, the Court should exercise extreme caution in drawing anything from this judgment, except the point on prejudice. And you see that in paragraph 57, because it is relevant to the exercise of discretion if the court is against me on my primary submission and wants to exercise its discretion under 310. We see at paragraph 57 that learned judge recognising that the loss of a limitation defence is relevant to prejudice. You see that paragraph balanced against that must be proper consideration of any prejudice caused the defendant as a result of the errors. Here there is prejudice of losing a limitation defence, and that can be prejudice as held in other cases. In that case, the learned judge found the overall prejudice wasn't substantial, but the point of principle was clear. Now, my learned friend, Ms. Smith, tried to take from paragraph 59 an argument that it was the defect that has to cause prejudice. But that's not what the learned judge found in paragraph 57. So that's my survey of the authorities. And so just to sum up, Venus, we say, is authority for the proposition that CPR 310 as a general proposition cannot be used to override specific provisions of the CPR. In particular,
I follow that. What Ms. Smith submitted was that there was a distinction between taking a procedural step defectively and either omitting to take any step at all or performing something which is contrary to a rule.
Well,
What do you say? And that distinction is one which I think Mrs. Justice Cockrell, or Sarah Cockrell QC, she was, alludes to in Bank of Baroda as well.
and we see that, and we see it in other authorities also,
Yeah.
where Venus was not cited.
Yes.
And to an extent in the decisions received to reconcile Venus and Phillips and Simon.
Is the short answer that it's still inconsistent with that line of authority, Venus and Elms, really,
Yes,
isn't it?
exactly. It's
Because Elms
inconsistent.
would fall into that category, I think.
Well, exactly, that's the answer. Is that the submission fails because it still operates on an unfriendly submission inconsistently with the principle in Venus and Elms.
Yeah.
Because however
But it still involves effectively overriding 7.6.
Yes, and 615.
763.
615. Indeed. That's my submission on that point.
I suppose, is this right? 615 will only apply if you have taken some step, because this is about validating your messed up step and turning it into an effective step. So that sort of case will always be a case in which somebody has done something. If you haven't done anything at all, you couldn't get through 615 would save you.
Indeed, and that's why 616 is there.
Right.
Because if you've done nothing at all, then you've got 616, which again the claimants applied under in this case and failed to satisfy the conditions for the application of 616. So that principle in Venus and Elms binds this court as it bound Justice Morgan, and it hasn't been overruled by anything in Phillips and Nussbaum. Now, if I'm wrong about that, if the court concludes that 310 is capable of being applied, we rely on our respondents' notices and we say that this court should not exercise its discretion as sought under 310 for two reasons. It would deprive the defendants of important limitation defences, and because the failures of the solicitors, the claimant solicitors, own. The judge below didn't address this because it was unnecessary for him to do so. And you see that in paragraph 93 of the judgment, no need to turn that up. But I will address you on the approach to the exercise of your discretion. And for that, I will go back to Barton. Because although Barton was a case concerning CPR 615, in our submission, the court should try to ensure some consistency between the approach under the general and the specific powers in the CPR to remedy defects in service.
Yeah.
So Barton is behind tab 15. And if you go please to page 277. And paragraph 8 is where we see the point which my Lord the Chancellor alluded earlier. It begins here, Lord Sumption says, the CPR contains a number of provisions empowering the court to waive compliance with procedural conditions or the ordinary consequences of non-compliance. Most significant is to be found in CPR 3.9, which confers a power to relieve a litigant from any sanctions imposed for failure to comply. And then he goes on to say, these powers are conferred in wholly general terms, although there's a substantial body of case law in the manner in which they should be exercised. Skipping down below the citations, he said the short point to be made about them is there's a disciplinary factor in the decision whether to impose or relieve from sanctions of non-compliance with the rules or orders of the court, which has become increasingly significant in recent years. But then CPR Rule 615 is rather different. It's directed specifically to the rules governing service of the claim form. They give rise to special considerations which do not necessarily apply to other formal documents, other rules or orders of the court. Moving on then from that distinction between the general and the specific.
He doesn't actually focus on, as it were, the Venus point, and Venus wasn't cited.
No. So what Barton really does is it sets the tone, it sets out the point of principle for how one approaches the construction of these rules. Because later on, Lord Sumption goes on to say there is a need for certainty and for bright line distinctions on these important questions of validating defects in service, which would be entirely inconsistent with a broad power under 310 to do that which
Yeah.
couldn't be done under 615 or 616 or 7.6. But on the question of exercise of discretion, paragraph 9, we see the question of what constitutes good reason for validating non-compliant service is essentially a matter of factual evaluation, and he relies on the judgment in Bela and the judgment of Lord Clark. And if you turn over to page 278, very top, service has a number of purposes, but the most important is to ensure that the contents documents are brought to the attention of the person to be served. This is therefore a critical factor. However, because of course that's a point that my learned friend Ms. Smith has made, however, the mere fact that the defendant learned of the existence and content of the claim form cannot, without more, constitute a good reason to make an order under that rule. And then 10, Lord Sumption says, it's not a complete statement of the principles in which the power will be exercised, the facts are too varied to permit such a thing. But he goes on then himself to summarise the key requirements. And he says, in the generality of cases between D and E, the main relevant factors are likely to be 1, whether the claimant has taken reasonable steps to effect service in accordance with the rules. 2, whether the defendant or his solicitor was aware of the contents of the claim form at the time when it expired. Might add 3, what, if any, prejudice the defendant would suffer by the retrospective validation of the non-compliant service of the claim form. Bearing in mind that he knew about its contents. And none of them are decisive, the weight to be attached will vary with all the circumstances. And if you go please to page 280, this is the point, I'm sorry I'm skipping between my submissions, but I mentioned the point of principle about bright line distinctions. And
Yeah.
here you see it in paragraph 16. In fact, it may be easier if the court has read paragraph 16.
We read 16 to ourselves.
Yes, please.
No, I was just going to say, I'm slightly puzzled by the sentence that says it's an order under 615 necessarily has the effect of further extending that's to say, the period of validity of the claim form or extension of the limitation period. Because if it's a retrospective, it's simply validating what's already happened.
I see my Lord's point. It may be that Lord Sumption there is referring in the.
He's referring to a prospective order.
That may be
Effectively, if you've tried, the classic examples where you've tried to serve defendants being evasive, you apply for an order for service on a solicitor or whatever.
Indeed.
And so in that case, of course, there would be
It would operate
an
then.
extension of time. Yeah, I
In
thought,
effect.
yeah, okay, thanks.
So, and the very last point I want to take from Barton again goes back to the question of whether depriving a defendant of a limitation defence counts as relevant prejudice. And we see that on page 283. And this is the courting disaster passage, middle of paragraph 23, between E and F. Because he says, a person who forces disaster in this way, who leaves things to the last minute, can only have a very limited claim on the court's indulgence in an application under 615, and I would add under 310 also. By comparison, the prejudice to Wright Hassel, the defendant, is palpable. They will retrospectively be deprived of an accrued limitation defence applicants if service is valid. And if we rely on that, because it's common ground that the defendants will be deprived of limitation defences if the power under CPR 310 is exercised to treat service of the unsealed claim form as valid service on the 17th of July. And you've seen, I'm not going to go back to the authorities, but just to sum up for the court's note, you've seen the support in the case law for that principle that expiry of limitation is significant prejudice. It's in, you saw it in Baroda between paragraphs 18 and 19. You saw it in Piepenbrook at paragraph 82, little 5. It's in Boxwood. I'll give you the reference for that because I haven't taken you to Boxwood. Authorities 19, page 400 at paragraph 51. And you've just seen it in City Sprint at paragraph 57. And in fact, my friend Ms. Smith positively relied on the point that there are periods of claim in respect to which the defendants would have limitation defences if you didn't make the order she seeks. Valuable limitation defences because the periods involved cover several years. She made that point in her favour. In our submission, that's a point in our favour. The question of prejudice goes one way in the cases. We saw it in Barton. The question is whether indulging the applicant will prejudice the respondent who would otherwise have a good limitation defence.
Some of the claim forms were issued in 2017.
They were issued.
So the effect of any sort of retrospective validation would be that your clients lost 4 years worth of limitation.
Just slightly less, but three and a bit years.
Three and a bit,
yes, yeah, indeed. It's common ground, they are valuable periods. So the next factor in the exercise of the court's discretion, applying Barton by analogy, is whether the claimants took reasonable steps to effect service in accordance with the rules. And for this we turn to the witness statement of Ms. Holloway in the supplemental bundle at tab 8. If you go please to page 61, paragraph 24. Ms. Holloway says at paragraph 24, bottom of page 61, the avoidance of doubt, I'm not suggesting that the task was too onerous to achieve in the timescales available. So all of our discussion about the amendments that we made, significance.
Sorry, which paragraph?
Paragraph 24, my lord.
Yeah. Okay.
It's a sentence I think that you've drawn attention to your friend Ms. Smith yesterday. But and Ms. Holloway very frankly and fairly acknowledges that. So the description of the work that has to be done really is just context. She's not suggesting the task was too onerous to achieve the timescale available. But then over the page, this is important, to paragraph 25, she says that in her firm's experience, it can take anything from an hour to 1 business day or more for the court to provide a sealed copy of a document filed via CE file. We infer that was the knowledge at the time, because Ms. Holloway speaks to knowledge she acquired later, then she speaks to knowledge she acquired later, like the court charter. She says she realised subsequently that it provides for a particular period. Paragraph, then you go down please to paragraph 30, please. And she says that the description of the approach in the CE filing system isn't a criticism, and she refers to the CE file login page, which says advice and guidance during COVID-19 outbreak. The e-filing service is still available for users to submit filings, carry out public searches and request office copies. The most urgent filings are being dealt with as a priority. Therefore, you may experience a delay in the processing of routine filings. So the claimant solicitors knew that it could take more than 1 business day to to get a sealed claim form, or more, with possible further COVID delays. But they still waited until the very last day to file. And you see that the times of filing, partly in this statement and partly in the annex. So in this statement, if you go back to paragraph 27, on page 62, for Visa, you see that the ideal shopping claim, amended claim form was filed at 12:43 on the 17th of July. And over the page, the amended claim form for Vodafone was filed as late as 15:23 on the 17th of July. And there's a reference there, if you go back, on that same page, page 63, you see that for one of the claims, this is against Mastercard, Grove F&B Limited, paragraph 29, it was submitted on the 17th at 9:58, but actually accepted at 15:52 on the 17th. So they had a sealed claim form for Grove F&B on the 17th. But even then, they didn't serve the sealed claim form on time because the unsealed claim forms had by then been sent by email. So there was no sense of urgency in sending these claim forms. And you get that also from the Mastercard times. I won't take you to them, but they also stretch into the late afternoon. The reference is supplemental tab 10, page 118. There's no sense of urgency in the filing of these claim forms, and the reason is clear. And it's the same reason why for Grove F&B, the sealed claim form wasn't served, even though they actually had it by 4 p.m. on the day of the 17th. It's because the claimant solicitors believed that service of an unsealed claim form was valid service under the rules. And we get that from Ms. Holloway's statement at paragraph 34, page 65. At the very bottom of paragraph 34, she says, "It did not occur to me, or as far as I'm aware to any member of the team working on the claims, that it was necessary to have the sealed amended claim forms in order to effect valid service." Now, as Mr. Castles said in his second statement to paragraph 19, one kind of personal sympathy for Ms. Holloway in this situation. But there's no doubt that Scott & Scott is a major international law firm specialising in just this kind of complex, multi-party, antitrust commercial litigation. And so all of the evidence of the delays in CE filing and so forth is irrelevant. The claimants knew that it could take more than one business day, but they waited until the last day, in many cases late on the last day, to file anyway.
But in any event, if you file something on the afternoon of Friday the 17th of July, you're taking forget COVID, you're taking a chance, aren't you, that nobody in the office downstairs looks at it until the Monday morning. Indeed. You know, staff go home at 5 o'clock. So if you file it at, one of these claim forms was filed at 4 o'clock or just before 4 o'clock, the chances of somebody looking at that before they went home, not great, really.
And when a major international law firm takes that risk, that is highly relevant to the exercise of the court's discretion.
Well, I mean, as Ms. Holloway accepts, they thought that serving the unsealed claim forms was good service.
Well, those are my submissions on the exercise of the discretion. Yeah. And I move on now to the undertaking. This is my appeal.
Yeah.
And it's a short point. For this, actually, if you keep the supplementary point, I'll take you to Mr. Castle's first witness statement.
Yes. Which is where?
Behind tab 2. Go to page 5 of that, please. You will see the undertaking. And the undertaking was the price that Visa demanded to be paid in return for the extension of time that was agreed with the claimants. I'll come back to the text of the undertaking because I'll give you the background from paragraphs 12 and 13 first. So if you could actually read, please, paragraphs 12 and 13 to yourselves, that gives you the rationale for the undertaking. And I'll come back to the text of it afterwards. So, my lord, my lady, what's clear is that Visa didn't want the claimants to bring the proceedings to an end in any way and reissue, because we thought we'd be worse off from a limitation perspective in the post-directive world. That was our concern. And the claimants, and this is clear, didn't need to sign these undertakings, but they did so, presumably on advice, in order to get the benefit of the extension of time for service. So coming then to the text of the undertaking, and that's in paragraph 11, and it's in two parts. So we'll take the first part first. Our clients hereby undertake to each of the defendants and to the court not at any point in the future to discontinue, withdraw, or otherwise bring to an end the proceedings and issue a further claim or claims in substantially the same or equivalent form. The question is, what does or otherwise mean here? In our submission, as a matter of ordinary English, the words or otherwise must mean not what went before. In this context, that had to include leaving the unserved claim form to lapse, because if you're not discontinuing or withdrawing, how else can you bring a claim to an end? Because of course, if a claim form is issued but not served, the most straightforward and cost-effective way to bring that claim to an end is simply not to serve the claim form. Natural meaning, we say, is entirely consistent with the purpose. Because it made no difference to Visa if the claim form was withdrawn or left to lapse unserved. Both allow the claim to reissue and get the benefit of the procedural provisions in the directive, which is what we wanted to prevent. And of course, it's irrelevant from our perspective if the claim form is left to lapse deliberately or accidentally. In view of the purpose of the undertaking, that didn't matter. Either way, the claimants would be free to reissue and rely on the damages directive. That construction, we say, is obvious from the purpose of the undertaking, but also as a matter of commercial reality. It's far too uncertain to leave it to the claimant's statement of mind. That is, to make a distinction between allowing the claim form to lapse deliberately or accidentally. It's far too uncertain, we say, and in any event, Ms. Justice Morgan didn't determine the point and assumed it in Visa's favour. So we move on then to the second part of the undertaking. Whether to seek some form of perceived advantage under Directive 2014/104/EU as implemented by Member States in due course, or otherwise. Whether to seek some form of perceived advantage under the directive, and I emphasise comma, or otherwise. And again, or otherwise means not what has gone before. What has gone bore is reissuing to seek some form of perceived advantage under the directive. The undertaking makes clear that it applies whatever the reason for reissue. That's the significance, we say, of that final or otherwise.
So it's whatever the reason.
It's whatever the reason.
Even if there wasn't a reason, as it were.
Exactly, that or otherwise is to capture every circumstance. It can't depend, I mean, that's a matter of ordinary language, but also as a matter of sensible construction. It couldn't depend, it wouldn't be commercially real to make it depend on whether the claimants were reissuing in order to get some perceived advantage under the directive.
But one difficulty with that argument, as I see it, is that it renders odious the whole of the words after the words in substantially the same or equivalent form. You might just as well have ended the sentence there, because then you'd have, as it were, which is what you're arguing for effectively, is a complete bar on commencing fresh proceedings if you've on this hypothesis brought them to an end. So the rest of it's just completely odious.
It's surplusage. I can't disagree. It would be much easier if we put a full stop after equivalent form. But the effect of the or otherwise.
Well, doesn't that suggest that if you're trying to make commercial sense of it, that it's not, that's not the meaning
My Lord,
to be given to it?
with respect, no, because the reference to the directive highlights one of the concerns, the main concern that Visa had in expecting the undertaking, in demanding it, but the or otherwise made clear that it didn't depend on whether the claimants were going to reissue in order to get a perceived advantage from the directive. It was to capture any reason. And one can see why. The reference to the directive is there because it explains the basis for the undertaking. But the or otherwise is inserted to make sure that the thing doesn't depend on the internal workings of the claimant's mind that they would reissue in order to get some perceived advantage from the directive. Which is why the or otherwise is inserted to make sure that it applies for whatever reason, because that secures the objective of the undertaking.
Why doesn't it mean, why isn't it aimed at making sure that whether you intended to get a benefit from the directive isn't relevant, but if you get a benefit, then you can't reissue?
But again,
In other words, the or otherwise is meant to capture any reissuing which gives you a benefit, whether you intended it or not. But that's all.
my Lord, I see that. The difficulty with that respect is it is also far too uncertain. Because whether a claimant gets a benefit or not under the directive could be a very complex process. It might not be possible to ascertain that until the end of a trial. Limitation may not be determined as a preliminary issue. And this undertaking was being sought, as Mr. Cass has explained, not just for the purposes of straightforward English law proceedings, because we saw that actually for the UK, the directive was implemented in a way that didn't give rise to the concern that we had. But it could be relied on. The claim could be brought in respect of non-UK MIFs brought in England where foreign law would apply. And so it would be far too uncertain to make this depend on whether ultimately the claimant's benefited or not. The sensible commercial
Why
reason.
would it be uncertain? Because the obvious benefit, I mean, this is really directed at limitations, isn't it?
Yes.
I mean, I suppose one could conceive of some slightly outlandish change in the law to enable you to claim punitive damages or something that the claimants might discontinue and start again to take advantage of something of that kind. But that's pretty far-fetched, and I can't imagine anybody objectively would be thinking of that. It's really limitation. So it's picking up, isn't it? Seeking to discontinuing, putting it neutrally, whether discontinuing for what you perceive will be an advantage either from the directive or some other way for limitation purposes. Anyway, we've got your submission. I mean, it's a very short point, really, isn't it?
It is a very short point, but I mean, the problem, I mean, I see what I said, my Lord says, Lord but the problem with that reading still is that if that was what was sought, it would say to seek some form of perceived advantage. Well, whether under the directive as implemented in due course or otherwise, that would make clear that only if an advantage was being sought or obtained, the undertaking would bite. But that's not how it's drafted. The or otherwise is plainly there to sweep up all circumstances. Because otherwise the undertaking doesn't secure the very clear purpose that would be understood by the parties entering into it, and becomes very uncertain because it depends on questions of perceived advantage, whether ultimately an advantage is obtained or not. The limitation point may not be resolved cleanly. There may be a debate then about whether a limitation defence has worked in whole or in part. It gives rise to far too much commercial uncertainty. The construction for which we contend is much more clear. It corresponds with the objective of VISA, and also from the claimant's perspective, they would have nothing to fear in giving, it's my last point on this, they would have nothing to fear from giving an undertaking construed as I maintain, because to avoid the consequences that have befallen them now, all they had to do was serve the claim form on time. If they were taking advice about entering into the undertaking as I am construing it, if they'd asked the lawyers, well, what's the risk here? And they said the only risk arises if we don't serve the claim form on time, which one can imagine them saying, well, that's not going to happen. Unfortunately, that for their perspective, that is what has happened. And so this undertaking does bite, and that's really my submission on it. And those are my submissions.
My lords, my lady, can I start by addressing Mr. Kenley's submissions on the visa undertaking and ask you to turn, if I may, to the judgment below on that. You weren't taken to that by Mr. Kennelly, but I do think it's important to look at it. It's in the core bundle, tab 14.
Yeah, hang on a second. Let's just clear the decks.
Yeah, the judgment is core bundle, tab 14.
Yep.
And this relevant part of the judgment starts on page 194.
Yeah.
Where the judge, under the heading the undertakings, he sets out the undertaking itself and the background, and then his reasoning starts at paragraph 105 on page 196. He addresses the first element of the undertaking in paragraph 106, says the first point is, did Ideal or Vodafone claimants bring to an end the earlier proceedings? And then I'd highlight the, towards the end of that paragraph, the sentence starts, although the point is not wholly clear, I agree that Ideal or Vodafone committed breach of the undertaking if they deliberately failed to serve the claim forms in time in order to produce the result the proceedings were at an end, so they could then achieve an advantage by bringing fresh proceedings in the way described in the undertaking. It's more arguable whether they bring to an end proceedings where their omission to serve the claim forms was the result of a mistake, and where they, and importantly, I would stress, where they've applied to the court under the various rules in order to avoid the proceedings coming to an end. And, I would stress further, where that result is opposed successfully by Visa. I am inclined to the view that Ideal and Vodafone do not bring to an end the proceedings in those circumstances. But he then goes on to say at 107, I will assume in favour, however, I will assume in favour of Visa, the omission on the part of Ideal and Vodafone to serve the claim forms means they did bring an end to the proceedings. And he then goes on to address the second element. And that is, at the end of paragraph 107, whether to seek some form of perceived advantage under the directive as implemented by member states in due course or otherwise. He makes the point, which I hope is uncontroversial, at paragraph 108. It's clear Ideal and Vodafone did not bring to an end the first proceedings to seek some form of perceived advantage under the directive. And then he goes on to address the meaning of otherwise in paragraph 109. It can mean in a different way or in different circumstances. He holds that it means in a different way. And that is, he says, towards the end of paragraph 109, the proceedings need to have been brought to an end and further proceedings issued to seek some form of perceived advantage, one, under the directive, or two, in a different way. with this interpretation of the undertaking, Ideal and Vodafone would not act contrary to the undertaking by bringing to an end the first proceedings and issue further proceedings in the present circumstances, because they are not seeking a perceived advantage in any way. He goes on to say that this interpretation gives a reasonable commercial meaning to the undertaking and comes to the conclusion in paragraph 111. He prefers the construction that means add that in the circumstances of this case. And you can read the rest of that paragraph for yourselves. My lords, we say that the judge was correct to reach the conclusion he reached on the second element of the undertaking. We say further that his inclination as regards the first element of the undertaking was also correct, and that your lordships should hold that neither of the two elements of the undertaking were fulfilled in circumstances such as the appeals in the present case.
You say there's a world of difference between deliberately letting the proceedings lapse so you can start again
Yes.
with whatever perceived advantage is.
And fighting tooth and
as it
nail
were,
to keep them
fighting
alive.
tooth and nail to keep them alive
Yes.
and lose it,
Yes, my
which
lord.
is really what happened here,
Absolutely, my
as far
lord.
as the Court of Appeal,
Yes.
as it were.
Yes. So, my lord, that really, in a nutshell, is
Yeah, I mean, that's, that. You know, we'll obviously have to
have our
decide for
submissions.
ourselves, but I see the force of your submission there.
So, yes, that's our submission on the first element.
And the second element is really, I mean, the question is a very short one, isn't it? Is whether the words or otherwise
Yes.
effectively are qualifying the perceived advantage,
Well, my lord,
or having some other broader meaning
yes.
that Mr. Kennelly contends for.
And our submission on that as well is short, which is that the judge was right to consider that the words or otherwise meant an issuing of a further claim in order to seek an advantage in either under the damages directive or in some other way, as some other advantage. Our submission is that in order for the undertaking to have the meaning intended for by Mr. Kennelly, effectively one would have to ignore all of the words after whether in the undertaking. They would, as the judge I think put to Mr. Kennelly, be otios. Because if it is the case that for whatever reason you start new proceedings, you're covered by the undertaking, why have those words at all? And we say that Mr. Justice Morgan's interpretation does not introduce an uncommercial or subjective element into the undertaking. The court can objectively determine, as Mr. Justice Morgan did, whether the proceedings were brought to an end to achieve an advantage or not. That's paragraph 108 of his judgment. So our submissions are that the visa undertaking does not apply to cases such as those in the present appeals. Then if I can go back to the two grounds of our appeal. First of all, ground one, and I would like to address 4 points arising from the submissions made by Mr. Hoskins yesterday. The first is that Mr. Hoskins made a number of submissions on the meaning of the particular rules under the CPR and as to whether or not those rules themselves required service of a sealed claim form by reference to what is said in the White Book notes. And he drew your ladyship's attention in particular to paragraphs 623 and 632 of the commentary in the White Book. And he repeated on a number of occasions that this commentary described the court practice. And he repeated those magic words, the court practice, on a number of occasions. Specifically, he made the submission, you might recall, that when in the White Book commentary reference is made to the judgment in Hills, the authors of the White Book were not actually relying on that judgment, but simply describing court practice. He also said that he referred this court to the judgment in Hills, and he said, paragraphs 60 and 61 of the court's judgment reflected, and I quote, the understanding of everyone that claimants are required to serve a sealed claim form. Now, by his reference to court practice and everyone's understanding, in my submission, Mr. Hoskins effectively sought to elevate practice and understanding to the status of a court rule or to the status of a legal requirement. And we say that's clearly not appropriate or helpful. And we say particularly it's not a correct approach as a matter of principle, just to say, well, that's how it's always been done, therefore that's the law. It's also not a correct approach when, as Mr. Hoskins, I think, fairly accepted, the reason why something may have been general practice, in this case, the service of a sealed claim form, was because, under the old procedure, as Mr. Hoskins himself put it, it was meaningless to talk of an unsealed claim form, an unsealed and issued claim form, because, and I quote, he said, you would never have one.
But the fact of the matter is that the notes in the White Book reflect what is said by Mr. Justice Ramsey. I mean, we haven't looked at Judge Wood's judgment, but my recollection is he says the same thing, which is, as it says in 6323, the general rule is if service is to be properly effected on a defendant, a claim form in the second category, that's an original sealed claim form, must be served.
Well, my lord, you've heard my submissions on the judgment in Hills. First, that it was concerned with a photocopy rather than original, and no consideration was made, or no consideration was given by the court to the question of a sealed versus an unsealed claim form. In those days, and it was also, my second point, based on the fact that in those days there was no such thing as an issued unsealed claim form. So the question of whether a seal was necessary or not was not before the court in Hills, and would not have been before the court in Hills because of the facts that obtained at that time. Before the advent of the pilot, there was no such thing as an issued but unsealed claim form. And that leads me to my second point, which is the difference under the pilot between the first stage of the procedure, that is the filing or submission and issuing on the one hand, and the second stage of the procedure, the acceptance and sealing. And my point, which I say is at the very heart of this case, which is the introduction under the pilot of a break between those two steps in the process, a gap, not just as to time, because there is a delay that is introduced that was never previously there, but also a move or a change in control of the two steps of the proceedings. Before, as I've said, filing or submission, issuing and sealing were all within, in effect, the control of the claimant, the claimant's representatives. Under the new regime, the two stages are broken apart, and the second stage is taken away. The control of the second stage is taken away from the claimant's representatives. There were questions raised yesterday by your Lordship, Lord Chancellor and Lord Justice Birss about when a claim form is issued under the practice direction, under the pilot. And I'd just like to briefly, if I may, look back at those provisions and try to shed some light on what was said in the first instance judgments in Dory and City Sprint in that regard. If I could just ask you to go back to the authorities bundle. The practice direction is right at the back in tab 25. And I made one or two points in this regard yesterday, said I would return to them in reply. If I could ask you to look first at page 494, paragraph 2.1 of the pilot practice direction. And this says, as you'll have seen, that electronic working enables parties to issue proceedings and file documents online 24 hours a day, every day, all year round, including during out of normal court office opening hours and on weekends and bank holidays, except, and then there are three limited exceptions, essentially when the systems are down, or there is a limited exception, I think, under the insolvency rules. So the whole point of the introduction of electronic working is to allow not just documents to be filed, but also proceedings to be issued outside court hours. One can see, for example, and I think in the various policy papers that were produced, what was in mind was, for example, we have international parties litigating, parties in other countries litigating. They are able to issue proceedings outside the UK court hours, within their working hours, for example. Now, if this court held that under the practice direction, issuing only actually takes place upon acceptance by the court staff, acceptance can only happen within court hours, obviously. And we say that's contrary to the clear wording of paragraph 2.1. It's also contrary to the clear purpose of electronic working under the pilot. And it significantly undermines in our submission the acknowledged benefits of electronic working, which enable documents to be both filed and issued outside court hours. On page 496, we move on to the general rules regarding issuing and filing. And those go together in the heading, both issuing and filing. We say they are simultaneous under the rules. And if you look at 5.1, 5.2, 5.3 in particular, although it is not drafted in the most easy way to follow, it does in our submission lead to the result that documents are submitted, filed and issued at the same time, and that is a separate step from the subsequent step of sealing. So if you look at paragraph 5.3.1, towards the bottom of page 496, you see that submission of a document using electronic working will generate an automated notification acknowledging the document has been submitted and is being reviewed by the court prior to being accepted. And you saw an example of the automated notification produced, or an automated notification produced, pursuant to that paragraph of the rules, that's supplementary bundle 41, tab 41. And if I could ask you just to have that open at the same time as the rules, you see the automated notification, the first stage automated notification, supplementary bundle tab 41. And you'll see this was an example of a notification in a claim issued, not one of the claims subject to these appeals, but issued subsequently. And you'll see that that automated notification email is not a reply email to anything. So what's in the heading is not a reply to what was in a previous email. It's an automated notification email. And you'll see that was issued, that was sent on the 15th of September, 1624. I went back and checked, 15th of September 2020 last year was a Tuesday. That will become, relevance of that will become obvious in a moment. It was a Tuesday. And it says, this is a notice to inform you that the filings, confirmation number, etc., have been submitted. You can view the filings here. Now, as I understand matters, that's an automated notification that was issued pursuant to paragraph 531 of practice direction. 532 then talks about the availability of CPR 310 under the practice direction, electronic working. Subparagraphs 3 and 4 talk about court staff filing a document once it has been submitted, and makes the point that refusal to include a submitted document on a case file is not the same as having failed acceptance. So again, that supports my submission that submission, filing and issuing are a separate step from the subsequent step of sealing. Paragraph 5.4 on page 497 of the pilot, the practice direction, subparagraph 1, in summary, says that the time of payment equals the date of filing for a document that is required to be filed, and a payment is required. Subparagraph 2, the time of payment equals the date of issue for claim forms and originating processes. Subparagraph 3, for all other document filings where there's no payment, the submission date is the date of filing. Subparagraph 4 says the following: once a document filing is accepted, this is where I say we move to the second stage, a notification, further notification, will appear on the electronic working online account registered to the filing party to confirm that the document has been accepted and to confirm the date and time of issue or the date and time of filing in accordance with the previous subparagraphs. And in my submission, it's not just a notification that appears on the online account. It would appear that further automated notification by way of an email is produced. And that, in my submission, is the email that's found at tab 44 of the supplementary bundle. And you'll see at tab 44 the same case number from what was at tab 41, but this email is dated the 17th of September, that's the Thursday, at 6 minutes past 9 in the morning. And that email, automated notification, says, this is a notice to inform you that the filings in this case have been accepted by the clerk. But although the notification is dated and timed the 17th of September, 6 minutes past 9 in the morning, we are told by this notification that they have been accepted on the 15th of September at 4:23. Actually, that's the date that they were filed. It's the date that appears on the automated notification at tab 41. So that's the second stage. And if you go through the link on page 220 at supplementary bundle 44, if you go through the link on that automated notification, you get to the sealed document.
Yeah.
Back to the practice direction, the paragraph. Paragraph 5.4, subparagraph 5, the date and time of issue or the date and time of filing of a document submitted will not be delayed by acceptance unless the submission fails acceptance. And then, and this is the, we say, very critical subparagraph, if the submission fails acceptance, notice of the reasons will be given, and I would underline the last few words of this subparagraph, it will be deemed not to have been issued. So what is deemed is that the claim form has not been issued. In other words, it is deemed, it is retrospectively invalidated. It is clearly on those words, I say, not the case that acceptance retrospectively deems the claim to have been issued. The words make it clear that a refusal or failure of acceptance deems the claim form not to have been issued. And we say that is clear from the wording of paragraph 5.4 subparagraph 6, but also makes sense because in the vast majority of cases, the filing will be accepted rather than failed. My final point.
Well, what this is saying is that effectively date of filing is date of issue. So if you file, you've issued.
Just not just that the date, in some way it's retro.
It's saying that when you file and issue, there is a sealed claim form in existence.
And I'll come to that. No, it's not saying that, my lord. We agree with you on that point.
So as at the 17th of July, when you filed, the effect of these proceedings is that your amended claim forms had been issued. If they had been subsequently, if acceptance had been refused for whatever reason, then what 545 is saying is that they're deemed not to have been issued, so you'd have to start again. But otherwise, what happens is that they're accepted, court seal is put on them, and it bears the date on which you filed them, because that is the date of issue. So that much is absolutely clear.
Well, my lord.
Where that leaves you on service is a very different question.
My lord, absolutely. Absolutely, my lord. But there were questions put to me yesterday about what was the status of the documents that were served on the 17th of July.
Do we have an answer to the question, which I think both my lord and I asked yesterday? Until the moment of acceptance, could a third party look at CE file and find the unsealed claim form?
We understand that you could go on to the CE filing website on the afternoon of the 17th of July as a third party and have seen that proceedings had been filed, or documents had been filed. What we sought to work out yesterday was whether, and I think this question was specifically put to me, you could find a claim form number from that, from the website at that stage. We could not, I'm afraid. We tried to put in and search a number of claim forms that were issued yesterday morning.
Our joint understanding is you couldn't,
Well,
because
we
they
couldn't.
don't get a claim form number until they're accepted.
We could not determine that. Well, when we went on yesterday morning, there were claim forms that had been issued, but appeared to have already been accepted. So we couldn't find anything to answer that question. I apologise.
Just to make sure I've understood the answer you gave just previously to the point you just made, you're not saying that in this case, if Mastercard had gone on one of the files and looked for your unsealed, unaccepted draft, whatever one wants to call it, claim form, issued claim form, they could have found that. You're not saying that. Because I don't think they could have, and I've listened very carefully to your answer, and I don't think you said they could, but I just want to be absolutely clear that that's the position.
No, but I don't think they could. The wrinkle, of course, in this case is that there already were originating sealed claim forms on the CE filing system.
Was a file that was originating.
Yes, exactly.
Yeah.
Yes.
So if we turn it into an original claim form that's filed on the afternoon of the 17th, but at that stage not accepted, you could go on to CE file and find that something had been filed, but you couldn't actually see, you couldn't find a way of getting into to see the actual document.
But they had received by email amended claim forms bearing the same claim number.
We understand that point.
Yeah.
We're just trying to get
as the originating claim
the
forms that were on.
logistics of CE file.
CE filing, yes. So just before I move away from the practice direction itself and the pilot, if unless there are any further questions, just to finally look at paragraph 7.1, which we say, again, clearly makes the distinction between the process of issuing and submission and acceptance and sealing subsequently. Also, paragraph 7.1, importantly, is subject to, as you see from the last few words of that paragraph, the provisions of paragraph 5.4. So there's this distinction between issuing, filing, submission on the one hand, and sealing on the latter. The points were also made on the judge's understanding in the courts below in the cases of Dory and City Sprint most particularly. I could ask you just quickly first, not even quick, just if I could ask you first to turn to Authorities Bundle tab 16, which is the judgment in Dory. Page 296 to start with, please. Authorities Bundle tab 16. Yes. My lord, page 296.
Yeah.
And just to clarify the factual situation in Dory, you'll see paragraphs 24 and 25. The claim form that was issued at issue in that case doesn't have a claim number or an issue date or a seal, but signed with a statement of truth. Equally, the particulars do not have a claim number attached to them, but accompanying those documents was the e-filing submission confirmation. Appears to have been in a slightly different form from the ones we've seen in the supplemental bundle here. But the point is, paragraph 25, from this it would be apparent that a claim form had been CE filed and issued that day. I should say the time. The date is the 14th of November, 4:19 p.m. So in other words, shortly before the letter accompanying the claim form was handed to the guarantor's solicitors. So in that case, the claim had been filed and issued in the understanding of the judge and in our understanding of how the rules work as well, at the date and time on the e-filing submission confirmation. And in that case, on the facts, just like in ours, the claim form had been issued and filed before it was served on the solicitors, the other defendant solicitors. Now, I'd ask you also, before we leave that case, to look at paragraph 97(2) of that judgment, which again really just makes the same points on page 309. That the claim form had been issued before it was sealed, before it was served on the 14th of November.
Sorry, 97.
97(2), page 309.
Yeah.
The guarantor was aware the claim form had been issued by the court. The guarantor received a copy of the electronic filing submission confirmation from the court's CE filing system delivered by hand in its offices on the 14th of November. The reason that the claim form was not sealed was that it had been electronically filed and the court had not yet provided a sealed version. Then there is a letter of the 2nd of December, so up to nearly 3 weeks later, where the claim number is set out, which demonstrated clearly if the guarantor and Watterson Hicks were not already aware of the fact the claim had been issued. So the claim number wasn't available immediately on the 14th of November, but appears to have been available subsequently about 3 weeks later on the 2nd of December. What was served on the 14th of November was a claim form unsealed and without a claim number, but with the e-filing submission.
Well, this seems to suggest that if you logged on before acceptance as a defendant solicitor, you could locate the unsealed claim form.
That appears to be the understanding of this judge, yes, but
And also you could
I'm very can't assist.
you could ascertain the claim reference number. which I find very puzzling, because I would have thought that they don't allocate a claim reference number until the claim is accepted, because otherwise what you're doing is using a particular number for a claim that then goes into the ether, and may, for whatever reason, if it's not accepted for some substantial reason, the claimant may decide not to pursue the proceedings, and so you've allocated a claim reference number to something which doesn't exist.
I apologise, we did try to investigate that, but weren't able to do so. I suppose the only way one could have actually investigated it is by issuing a non-existent set of proceedings and immediately getting someone to try and...
Since I'm in charge of the business of topical, I want to know the answer to all these questions, but I'm quite happy to say I don't.
Well, my lord, there is...
I mean, if it matters, we could no doubt find out, but it may not matter at the end of the day.
I'm not, and this is the point I'm going to make, I'm not sure that it does matter, my lord, at the end of the day, in the facts of this case. It was just that your lordships did ask me to try to assist on that and to try to...
I'm very grateful for the investigations, even if they've come to nothing.
So, my lord, just to close off this point, I hope these issues, and I hope I can deal with it relatively swiftly, and that's the City Spring case, which is an Authorities Bundle tab 23.
Yeah.
Yesterday, in questions to Mr. Hoskins, the Chancellor, you indicated that in your view, Mr. Justice Fraser was mistaken in that case when talking about sealed claim forms being in existence at the time of his service. We agree that he does appear to have been mistaken in that regard. He does appear to have equated an issued claim form with the sealed claim form, because the subsequent sealing, as he held, was with the date not of acceptance but of issue, which, as you will see, as required under the practice direction. Now, Mr. Hoskins suggested to you, and I think he was mistaken in this regard, in fairness, he did say he wasn't sure, but he suggested the judge referred to a sealed claim form being in existence because an unsealed claim form was served on the 5th of August, by which time a sealed claim form was in existence and had been from the 27th of July. But that's not correct. The chronology in City Sprint was that claim form was issued on the 27th of July. The claimant solicitors served an unsealed but issued claim form on the 27th of July. And the question was whether they could rely on that service. The claim form was not sealed until the 29th of July, not available until the 30th of July. And then the solicitors served the sealed claim form that had been made available on the 30th of July on the 5th of August.
Yeah,
and the question whether was that subsequent service out of time? Yes, it was, because time started to run from the 27th of July.
Yeah.
So that was the chronology, and I don't think I need to go back and look at the judgment, but I think we agree with the Chancellor's instinct that Mr. Justice Fraser was confused when he referred in paragraph 52 to a claim form having been sealed.
Yeah.
Because he was equating the sealed claim form with the date of sealing with the date of issuing. Now that brings me to the third point I wanted to make on Mr. Hoskins' submission, which is this. In these appeals before your lordships, your ladyship today, the unsealed claim forms were served on the 17th of July because sealed claim forms were not available until the 22nd of July, because of this gap that I say has been created under the pilot between submission filing, issuing on the one hand, and sealing on the other, acceptance and sealing on the other. Now, Mr. Hoskins yesterday said, and I quote, "The point is, if you leave it, that is filing, to the last minute, you run a risk." And he said, well, what do you do? And again, I quote, he said, you just do it, filing, in time, and you don't have a problem. Now, my first point in that regard, and I do stress this to your lordships because there's a lot of undercurrents running through this case about courting disaster, etc. So I do stress to your lordships that there may be very good reasons why service is left to the last day. It's rarely, in my submission, as simple as solicitors just being too shambolic to file in time.
The difficulty with that submission is Miss Colway fairly accepts that it wasn't too onerous a task to have served sooner than they did.
No, my lady, what she fairly accepts is that it was not too onerous to have amended the claim forms within a month of the Supreme Court judgment having been handed down.
She doesn't vouchsafe some reason, some valid or legitimate reason for leaving it until the literally the last day of the limitation period.
Well, my lord, and I cannot
There may be
give
good,
you
there may very well be good reason.
evidence on that. Well, my lady, my lords,
If what you were seeking to do was to invite the court to exercise its discretion in one of the ways that was sought before the learned judge, which was 310, 615 or 616, it was incumbent on your solicitors to give whatever the valid reason was for failing to serve until the last day, because that would have been highly relevant to the exercise of the discretion.
well, my lord, in that regard, can I make the following general submission? That often, and I'm sure all of those sitting in court, this rings true with all of those sitting in court, often the court will be unable to be given an explanation as to why filing was only done close to the deadline for service. And I'm just speaking at general level here. It may be that a solicitor is having trouble getting instructions from their client. If so, those discussions are privileged and cannot be referred to in front of the court. It may very well be that a claimant's solicitors is engaged in without prejudice discussions with a defendant's solicitors.
But both of those, with respect, are not a good reason for leaving until the last minute. The first one is the client's fault. If the client isn't available, especially clients like these, then the client takes the consequence. All that goes to is whether there has been negligence on the part of the solicitor or whatever. And the second point is that there are clear authorities which say that without prejudice negotiations are not a good reason for delaying service until the very last minute.
Well, my lord, then, in my submission, the next point it becomes of crucial relevance. And this is...
Your fourth point.
It's under the third. But the crucial point then is, what does in time actually mean? When is the deadline for filing under the pilot? Is it a day before the deadline of service? Is it a week before the deadline for service? Is it 10 days before the deadline for service? Mr. Hoskins blithely says, if you do it in time, you don't have a problem. He has never suggested what in time means. And if I can in that regard, and this is the problem, the gap that is created by the pilot, my lord, if I can take you to the agreed chronology that was mentioned yesterday and again mentioned by Mr. Kennelly this morning. The agreed chronology is in Core Bundle tab 12.
So Core Bundle.
Tab 12.
Yeah.
And this is agreed between the parties. If I could ask you to turn to page 167, just to give you two examples of what happened in this case. My lord, my lady, you'll see on page 167 at 9:58 on the 17th of July, the filing receipt, so that's a document equivalent to that that's in supplemental bundle, tab 41, was received in the case of Grove and Mastercard. 10:12 on that morning, the filing receipt was received for Grange and Mastercard. And my lord, Mr. Kennelly this morning referred your lordships to the Grove and Mastercard case. And he made the point that the amended claim form was sealed and accepted on Friday afternoon. And that's correct. If you turn over the page, 168A, you'll see the very last entry into the table on 168A is that the filing receipt having been received in the Grove and Mastercard case at 9:58 that morning, the amended claim form was accepted and the the automated notification from the court had been received that the claim form was available, the sealed claim form was available at 3:52 that afternoon. On page 168C, if I could ask you to turn to that, you'll see, however, that the amended claim form in the Grange and Mastercard case was not accepted by the court, so a sealed version of the amended claim form was not available until 8:22 on Monday the 20th of July. I'll come back to what the implications of that are, but that's two examples of what happened in the present case.
Well, what seems to have happened then, in very broad terms, there's not an exact correlation, is that the notifications of acceptance of each of the claim forms in the same order as they'd been filed on the morning of the 17th.
My lord, yes.
It goes back to the point that I made earlier, which, forgetting the pandemic for the moment, if you file a claim form on the last day, and if as Miss Holway says very fairly in her statement, their experience was that it could take one business day or more before you got acceptance from the court, then this is exactly the risk that you were running, and that is exactly Mr. Hoskins' point.
Well, my lord,
if you'd done it, I don't know, maybe a week earlier would have been sensible, because then at least if there were a problem and the whole thing took, if CE file was taking 7 days, you'd have had a very good basis for saying to the court, please give us an extension of time under 763.
My lord, if I could address those points, you made them in to Mr. Hoskins in his submissions yesterday, and I want to address those points. But before I do that, can I take you just to evidence of what happened in related claims under the C filing, because I think it is relevant just to give you an idea of what happened. If I could ask you to look at Ms. Holway's second witness statement, supplementary bundle tab 11, page 125. Page 125, if I could ask you to read paragraph 11, which gives two examples of other related claims which are not subject to these appeals, where, well, I'll let you read the paragraph and then I'll summarise.
Yeah,
So
the example in 11A is one where, because there had been a delay of how many days it was, 7 days or whatever, you agreed an extension of time.
Yes, my lord, yes, and I if I could just make the following submissions then. You have examples of, we rely on these for the following points. First of all, the time that it will take is unpredictable. The time that it will take from between filing and sealing is unpredictable. And as I've said, risk of repeating myself, it is out of the claimant's representative's control. How do you deal with that? Well, first of all, yesterday, Your Lordship said, well, perhaps you should file the day before the deadline for service. That's what the Chancellor suggested yesterday would have been sensible under the old regime. Now, such a course may have been sensible under the old regime, where if the articled clerk, because he's been in the pub or for whatever other reason, doesn't turn up at the court door until 4:32, he can't get through the court door. He knows he can't get his sealed claim form today, but he knows that he will be able to get one at 9 o'clock tomorrow morning when the court office opens, because he can come back and he'll get it back over the counter the next day. So he knows that if he misses the deadline on the Thursday, he can come back on the Friday. But in a case like those under appeal today, we say the claimants could not have reasonably known that if they filed or arrived at the virtual court door with the claim form in the Grove case at 9:58 on Friday, they would get the sealed claim form by the end of that day. But if they arrived at the virtual court door 14 minutes later with the Grange claim form at 10:12 on Friday the 17th of July, they wouldn't get that claim form sealed until the next day.
So they couldn't reasonably have known.
No.
What, in circumstances where
You
the
just told
evidence
us it's
is
on
that they knew that it might take more than one business day?
Well, the evidence was it could have taken 90 minutes.
No, the evidence from Miss Holloway was that, never mind the charter, the experience of her firm was that it could take one business day or more.
The evidence from Miss Holloway was it could take anything from between, it could take up to 1 day or more. And her experience is, in some cases, it took 8 days.
I'm very, very confused, Ms. Smith, as to why it helps your case to emphasise that it's unpredictable. Because it seems to me that it plainly is unpredictable. And what normal people do when timing is unpredictable is they give themselves enough time to take away to give them as much time as they can to deal with the fact it's unpredictable. Only law firms seem to think that unpredictable means you can go to the wire because you can put your hand on your heart and say, well, I couldn't have known for sure whether it would have taken 10 seconds. It's completely mad. It's completely the wrong way around.
And if you've done it on the Monday, whichever day that was, the 13th of July, and you still got nothing by 4 o'clock on the Friday, then assuming, let's just say for the sake of argument, the defendants were obdurate and said they weren't prepared to agree another extension, then you could have made an application to the court for an extension of time, which would have almost certainly been granted on the basis that it was all the fault of the CE file system, or not fault is probably the wrong word, but delays within the system.
Can I make 2 submissions in response to that? First of all, in order for deadlines to work in my submission, they need to be clear. You don't get extra points for serving a document a week early if there are no problems. Court deadlines, for example, counsel need to lodge their skeleton argument on the Friday. You don't get extra points for lodging it on the Monday in the normal course of things. You don't normally get.
Well, except the judges who say, because your skeleton argument was filed late, I'm not prepared to read it. You haven't, haven't got the sort of limitation issues
Well, my lord,
that arise with
yes.
Initiation of proceedings.
I'm saying that in the normal course of things, you cannot be criticised for taking the full time you're given under a time for service. My second point is that you make the point against me that I think the suggestion was made yesterday by the Chancellor, you should file 10 days before the deadline to service so that you give yourself time to apply for an extension of time if it appears the claim forms are not being processed as quickly as they should. But my submission in that regard is first, when should the claimant reasonably have come to the view that you are not it's not going to be done in time. Again, a nebulous judgment, a nebulous deadline that is out of their control. The claimant has no control of when the claim form is sealed. Also, you say address this uncertainty by applying for extensions of time. Inevitably, this would create a greater additional administrative burden on claimants and the courts. If a claimant has to make an application for an extension of time every time they think there's a risk that their claim form might not be returned sealed within this 10 days by the time of expiry of service, every time a claim form is served, 2 weeks or more towards the deadline, the date for the deadline, an application will be made out of an excess of caution if that is what this court tells claimants' representatives they should be doing. And this will lead to the inevitable result that extra applications for extensions of time are made, as well as the filing itself, doubling the administrative burden not only on the solicitors but on the court staff, and creating...
This submission is just completely unreal with respect.
What?
Because, I mean, true it is your solicitor can point to one of the cases, not one we're concerned with, but another one in the same sequence, as it were, where because there was a problem of some description, it took 8 days. But the reality is that, as the chronology which you showed us shows, the claims forms were accepted effectively in the order in which they've been filed. The problem was that the weekend intervened. So if you had filed on the Wednesday or the Thursday, let's just say for the sake of argument, you would have got back, you would have had available for service sealed claim forms within, certainly before 4 o'clock on the Friday, probably by the Thursday afternoon at the latest. So the idea that somehow there'd be all these sort of endless applications for extension of time, that's only going to happen where something's gone horribly wrong, effectively. And that the evidence does not suggest that CE file regularly takes 8 days. If it did, well then you might have a point, but it doesn't.
Well, my lord, I'll close this point briefly then, given the indications that you've made. The purpose of the electronic filing pilot is the efficient administration of justice, in my submission. And it should be applied and it should be interpreted, I hope it's uncontroversial, consistently with the efficient administration of justice. It does, in my submission, the pilot, create a gap, a gap of uncertain time between filing and service. We do say that it is undesirable to say that how this gap should be addressed is that claimants should file their claim forms an indeterminate period of time before service in order to be on the safe side, when that effectively puts in place a deadline for filing predating the deadline for service, but the deadline for filing is not set out anywhere in the rules and is purely to be determined by the claimants in order to be on the safe side. It's a nebulous deadline. The rules on electronic working pilot at the moment do not provide clearly for what should be done in a case, which one hopes will be rare, where there is a longer period of time or a period of time between filing and service, which leads to the result that service is late. We say that in the absence of that, in that lacuna in the pilot, unless and until it is addressed, that lacuna in the pilot, it is just a pilot, and we do say this is a problem that has been highlighted by these appeals. We do say that if you are not with us, that the pilot and the rules should be interpreted in the way we submit under ground 1. The way of dealing with cases such as the present is that they can and should be remedied under CPR 310. And that brings me to ground 2.
So you did say you had 4 points.
I did. I mean, my 4th point was a very short point, which was essentially to ask your lordships to look. Mr. Hoskins said the email from the Court of Appeal Registry that was found at supplementary bundle tab 47, I don't need to take you back to it, I'll just make the point briefly. He said it was effectively an order under CPR 52.12.3. But actually the face of the email, when you look at it, makes it clear that we made an application for an order under that provision, 52.12.13. And the registry said, don't waste our time, you don't need to make that application, just serve the unserved claim form.
Well, it's just the way in which the Court of Appeal masters sometimes deal with things.
My lord, but then moving on to the, moving on then to the second ground, Rule 310.
Yeah.
And this is I make submissions principally on the point of whether, as a matter of principle, Rule 310 is available in the circumstances of the present appeals. First, in that regard, Mr. Kennelly said that in the first instance judgments of Integral, Baroda and Dory, the judgment of the Court of Appeal in Vinos was not before the courts who made those judgments. And he repeated that point this morning, in effect saying you can disregard what the court judges did in those cases because they had not had Vinos cited to them.
Yeah.
Technically, my lord, that's not correct. And I'll take you first to the Baroda judgment, but in that case, Sarah Cockrell, QC as she then was, referred to and relied upon the previous first instance judgment in the case of United Utilities. And she makes it clear by her reference to that case, she read that judgment obviously, and that judgment in United Utilities had itself set out an extensive citation of and analysis of Vinos and all relevant previous Court of Appeal authority. And further, she applied in that case, the judges in those cases applied the distinction which I say should and which can only have been taken from the Court of Appeal authorities between taking a procedural step defectively on one hand and omitting to take that step at all, or performing a step directly contrary to the rules on the other. So if I can just take you to Baroda first, which is in the authorities bundle tab 13. And if I can ask you to turn to first page 234. And you'll see at the bottom of page 234, paragraph 15 of the judgment. This leaves only CPR 310, as Mr. Watty for Claimants fairly acknowledged that this was not a case where CPR 616 could be paid in aid. In support of the claimant's submissions, I was referred to the judgment of His Honour Judge Graham Wood QC and United Utilities. She then goes on to explain what the case was about, and over the page at paragraph 16 she says, this case, that's the United Utilities case, as the defendants correctly pointed out, was not on all fours with the current case. However, it includes a very useful summary of the principles and recent authorities in the area, highlighting in particular, and I interpose but not only, Lord Brown's obit dictum in Phillips. And then while we're looking at Baroda, can I just re-emphasise what she says at the bottom of page 235, paragraph 19. This is a case where a procedural step was taken defectively rather than omitted or performed directly contrary to a rule. So she is applying this distinction, which I say is to be taken from the Court of Appeal authorities properly interpreted. it's not the same as the point that was expressed by Justice Peter Gibson in terms of a mini code in the rules, because that's a broad point. Yes, my lady, the subcode point that you raised yesterday. Yes, I'll come back to that if I may.
Well, the Judge Graham Wood, we haven't looked at his judgment, but she quotes him, doesn't she, in 17?
Yes.
Or rather, what she says is that the cases together indicate, and it's Roman 3, isn't it? The benefit of CPR 310 less easy to obtain where there's been no attempt at a procedural step, or the step taken is not permitted by or within the rules at all.
Yes. She summarises that.
That's the distinction you drew to our attention.
And subsequently, she
emphasises that.
Yeah, she refines the distinction, I would say, in paragraph 19.
Yeah.
But I will take you, if I may, to United Utilities. But before I go there, to make good the point that these Court of Appeal authorities were before the courts below. But before I go to United Utilities, just for your note, in the Dory case, which is the other judgment Mr. Kennelly relied upon or said did not refer to Vinos, the judge did refer to the relevant passages in Baroda, these passages in Baroda. For your note, it's paragraph 75, 84 to 85, and 95. That's in the Dory judgment where the judge cross-referred to these page characters in Baroda. But if I could take you to United Utilities, because it is a useful authority, particularly when this point has been raised against me. It's in Authorities Bundle tab 12. And you will recall that this judgment in United Utilities is cited in the notes to the White Book as well as containing a useful summary of the relevant principles.
Yeah.
And the facts of that case were relatively simple. A copy of a claim form in that case was served rather than an original. A copy of a sealed claim form rather than an original. And if I could take you to first page 208 of the judgment. In paragraph 13, you'll see the judge refers to the case of Hills and the case of Cranfield. On what the district judge held below that he was bound by those cases. Then on page 215, as you go through it, page 212 and 213, the judge sets out Cranfield and Hills in some detail. But on page 215, paragraph 34, the judge says, these are the only authorities to which the court has been referred which address the form of the documentary material to be served. I have already made mention of a series of cases which were concerned with the interplay of various discretionary powers where there had been some sort of deficiency in service. The first of these was a case called Vinos. And he goes on to consider the Vinos case in some detail. And towards the end of paragraph 34, before the quotation, he says the Court of Appeal, when faced with an argument that a discretion existed under CPR 310, considered in conjunction with the overriding objective to deal with cases justly, where that was being where what was being asked was to correct an error of procedure or extend time, held that the general discretion could not enable the court to do what was specifically forbidden by other rules. And then he goes on to quote what Lord Justice May said. So you'll see that he sets out the Vinos judgment in some detail. Over the page, on page 216, paragraphs 37 and 38, he also sets out in some detail the Court of Appeal judgments at paragraph 37 in core and at paragraph 38 in Elms. And then, could I ask you to turn to page 218, paragraph 42. He says said, "Is it clear from the cases referred to above that the senior courts have only considered the applicability of a broader discretion outside the service rules, parts 6 and 7, in cases where there has been no service affected at all? In other words, CPR 310 could not permit that which was disallowed by other rules." And then he goes on to address the exceptional category, which appears under 616. Then he refers in paragraph 43 to Phillips and Symes. And if I could then take you to, and he refers, in paragraph 44 to the decision of Popperwell in Integral. And the White Book notes in paragraph 45. And then in paragraph 47, on page 221, he records the respective arguments made, and the Defendants' Counsel, Mr. Wilkinson, submits that once, as the judge had decided, as he believes he was obliged to do on the basis of Hills, that this is a case where no service had been affected at all, it was not open to him to apply any discretion. Effectively, the Defendants' Counsel in that case was making exactly the same arguments made in this case. His powers were significantly circumscribed by the line of authority to begin with Venus, and whether this matter was approached from the position of broader discretion or the more limited and qualified discretions under Part 6. The submission was, the fact remains, he simply failed to serve. What the claimant is endeavouring to do is to circumvent those restrictive rules and to use 310 as a trump card, which he's not entitled to do. So that was the submission made by the defendants. The judge addresses those submissions in paragraph 58 on page 223. The last sentence of paragraph 58 is the question which is now before this court. The more difficult question for this appeal is whether such a discretionary power existed and its limits, whether under CPR 616 or CPR 310. And he goes on to address that question, and if I could ask you to turn over the page to 224, paragraph 62. It is accepted by both counsel that, notwithstanding the stricture of Lyson, LJ and Cranfield subsequently adopted by Ramsey, J and Hill, that there is no specification in the rules as to the form which service must take, and particular whether that seal referred to can be overcopied or must be transmitted in its original uncopied form. However, he says, because the parties are supplied with 2 sealed versions, it's not unreasonable to assume an expectation that one of these will be served on the defendant and one retained by the claimant. And then he goes on to look at the rules. If I could ask you to read paragraphs 65 and 66 to yourselves. We respectfully adopt what the judge says in paragraph 66, towards the end of that paragraph, that the requirement that an original sealed version of this claim form needs to be served appears to be born out of tradition and expectation rather than rule stipulation. And we also note, however, that he proceeds for present purposes on the basis that it was a requirement and the solicitor should have served the original.
Yeah.
And if I could also ask you to read what he says in paragraph 68, the context of Hill.
Yeah.
And then, if I could ask you to go over the page 226, where at paragraph 73, he says, I now turn to the line of cases beginning with Vinos. And he says, it seems to me that all these cases deal for the most part with the same principle, and that is that the general power under CPR 310 cannot enable the court to do that which it is prevented or not permitted under other rules. And if I could ask you to read paragraph 73 through to 78. And so I make the following submissions on those paragraphs. We respectfully adopt what the judge says in paragraph 75, say it applies equally to the circumstances in the present appeals. The court is not being asked to indulge a failure of the claimant who's failed to adhere to strict time limits, even though it's close to the wire. It's being asked to correct a perceived procedural error in respect of the form of the served document. And we say that is entirely on all fours with the facts in the present appeals. We also adopt respectfully what the judge says in paragraph 75 about the purpose of service. And that, just as in that case, this service purpose, he says, has been complied with, we say also the service purpose has been complied with in the appeals before this court. We therefore say, as the judge did in that case, we make the submission that there is a discretion available to this court under 310 to exercise. And we would also draw your lordship's attention while we're here to what the judge says in paragraph 78 about prejudice to the defendants. And we would underline that the judge there said that the judge below, the district judge, was right to consider 310 was an appropriate mechanism where any procedural defect had no prejudicial effect on other party, save by implication the loss of an opportunity to argue, such as happened here, the removal of a potential limitation defense. And that's what the prejudice is in this case. So finally, before we leave that judgment, I would ask your lordships to read what the judge says in paragraph 80. Although this judgment was rendered in 2015, what he says about the development of electronic working we say is particularly prescient, and we say equally applicable to the circumstances in front of your lordships on appeal. So I'd ask you to read paragraph 80 as well, please, of the judgment. Now, this judgment has been referred to in the White Book commentary as a particularly useful and full summary of the relevant principles, and I do recommend it to your lordships on that basis. So then can I move back to what Mr. Kennelly said about Court of Appeal authorities. I'm not going to repeat my submissions on Vinos, nor my submissions on Elms. You have those submissions. But I will pick up on what Mr. Kennelly said about the Steele judgment, because Steele is also an authority of the Court of Appeal of equal standing as those obviously in Vinos and Elms. But Mr. Kennelly, well, perhaps for reasons that will become obvious, sought instead to rely on Vinos rather than on the Court of Appeal judgment in Steele. So if I may take you to that judgment, which is in tab 6 of the authorities bundle. So we've been here before. Mr. Kennelly took your lordships to page 78 of the judgment. I can ask you to open that. And he highlighted what was said by Lord Justice Dyson between D and E on page 78 and paragraph 28 of the judgment. But for the reasons that we have given, the application of the 18th February 2004 was not in substance an application for an extension of time for service of the claim form. It was in substance an application to correct the applications for an extension of time, which were made within the time specified for service by Rule 752 and which by mistake did not refer to the claim form. To remedy the error contained in the applications and resultant orders does not circumvent the prohibition in Rule 763. Now, we also rely upon that statement by Lord Justice Dyson. We say Mr. Kennelly...
You get, don't you, from the previous paragraph, the distinction upon which you rely,
Yes.
stated
Yes.
by the Court of Appeal quite clearly.
Yes. And then applied to the facts
And then
of that
applied to
case.
the facts of that case.
And
yes.
we say it is equally to be applied by analogy to the circumstances of the present appeals. There is a direct analogy between the facts of the case in Steele and the facts of the cases before your lordships, your ladyship today, and I'll develop that point. Now, Mr. Kennelly said that in Steele, how it can be distinguished from the present appeals is he said there's no question of bypassing in substance something which is governed by a subcode under a different rule on the facts of Steele. He said there was no Vinos problem because no rule was being bypassed. And he contrasted that situation with the situation obtaining in the present appeals. Now, in that respect, we say, first, what is required, as set out by Lord Justice Dyson in Steele and in the previous Court of Appeal judgment in Vinos, is not simply that the facts of a particular case might fall within the ambit of another rule, but instead, as Lord Justice Dyson said in paragraph 28 on page 78, applying Rule 310 might circumvent the prohibition in the other rule. Or as he put it, and the Chancellor has referred to the previous paragraph, paragraph 27, as Lord Justice Dyson put it in paragraph 24 of his judgment. Actually, if we go back and look at paragraph 24 of his judgment on page 77, Lord Justice Dyson said, the problem arises where if the general language of Rule 310 is to be used to achieve something that is prohibited under another rule. And that, he says, is the principle established in Vinos. It's where the general rule is being used to circumvent a prohibition contained in another sub-rule, or to achieve something that is prohibited under another sub-code, as it were. That's our first point. Our second point is in response to Mr. Kennelly's submission that on the facts of the Steele case there was no Venus problem because no rule was being bypassed, in our submission is simply wrong. In the facts of Steele, on the facts of Steele, no claim form was served by the deadline for service. Either an original deadline, either the original deadline or an extended deadline, because the orders made by the court had been ineffective in extending the deadline, because they did not refer to the claim forms by mistake. So there was no service within time. Now, in that situation, the court could have made a further order for extension of time under Rule 6.3. That's an order that's made after expiry of the deadline. It could have made an order under Rule 6.16 to dispense with service, but it did not. The Court of Appeal made an order under Rule 3.10. And the Court of Appeal made that order on the basis, as Lord Justice Dyson put it at the end of paragraph 27 on page 78, there is a difference between making an application which contains an error and not making an application at all. And we say the situation in the present appeals before your Lordship today is directly analogous to that in Steele. In Steele, there was an error on the face of the applications and the resulting orders, so that they didn't refer to the claim forms, did not extend time.
Sorry, I'm sorry to interrupt you,
My lord.
Smith. You said a moment ago the court could have made an order under, did you mean 763? You said 63.
I said 763, I'm sorry, I should have said 763.
I've got a problem with that, because in paragraph 25, Lord Justice Dyson says it's common ground that an application on the 18th of February 2004 under 763 would have failed.
Well, my lord, this is exactly the point that's being made against me. The defendants say, well, your applications under 615, 616 failed below. You can't now seek to have them considered under 310. We didn't make an application under 76 below because we had served within time, although we had served a defective claim form. We did make applications under 615 and 616. And the respondents now say, well, because those failed below, you have no, in principle.
No, because the whole point about this case is really what Lord Justice Dyson says in the last part of paragraph 28, that it wasn't an application for an extension of time for service of the claim form. What it was an application to correct previous applications that had been made in time,
Yes.
but which had erroneously not included in the court orders made the claim form. So it wasn't that was the point.
Well, my lord, and we
correct
say
the previous applications which were in time.
Well, my lord, and we say that the situation in these appeals is directly analogous to that situation. The applications in the present appeals are to correct a mistake that appears on the face of the claim forms, in that they are not sealed, although they were served in time. Just as there was an error on the face of the applications and orders in Steele which had to be rectified, we say there is, by analogy, an error on the face of the claim forms in the present case. And we say, therefore, there's a matter of principle, 310 is available to remedy that error of procedure.
But surely there's a difference, because the sealed claim forms weren't available at the time, whereas in the Steele case, the application for extension was made in time. It was just a mistake. There was a mistake in it. Isn't there a difference in principle between the two cases?
Well, I'm not sure, my lady, that's a difference in principle, because I don't think that if there had been a sealed claim form available in the present case, and instead we chose to serve an unsealed claim form, the respondent's position would be any different. It would be perhaps even more, it would perhaps be urged even more strongly that we cannot take advantage of 310.
Not really the point I was making about it. It's an unclear question.
Well,
Yeah, okay, so we've got that.
well, my lady, I think the further point I want to make, which is relevant not only to points Mr. Kennelly made and to what your ladyship said just now, is also relevant to the points made by Mr. Kennelly relying on the Serbian Orthodox Church case. Are we bypassing, he said you are bypassing Rule 615, service by an alternative method. He relied on the Serbian Orthodox Church case and he made that submission, I think a similar submission to that being urged against me now by Lady Justice Laing. We say we did not bypass Rule 615, and I will explain why. Rule 615 relates to service by an alternative method to those permitted in Rule 6.3. Now, the permitted methods in Rule 631A to D include electronic service in accordance with Practice Direction 6A. We did serve by the permitted method of electronic service, which had previously been agreed with the defendants' representatives, and we did serve in accordance with Practice Direction 6A. There's no allegation we didn't. We rely on what Mr. Justice Morgan said below in paragraph 63 of his judgment, is that what we seek is not a change in the method of service, which would have been covered by 615, but a change in the thing that has to be served. And we say that is very different from a case such as Barton and Piepenbrook, where service was not in accordance with a permitted method. Because in our case, Practice Direction 6A, paragraph 4, on electronic service had been complied with, whereas in those cases it hadn't. In our case, there was a defect in the thing served, in the object served. There's no CPR subcode in our submission governing the need for a sealed claim form or making provision for what application needs to be made when a sealed claim form is not served.
And which paragraph of Practice Direction 6A are you referring to?
Practice Direction 6A, Part 4, off the top of my head, this is the part of Practice Direction where the judge found in Barton and Piepenbrook had not been complied with on the facts of that case, those cases.
You're not saying defect in this case?
No. Sorry, I made myself. So, my lords, my lady, that it's for those reasons that we say, as a matter of principle, Rule 310 was available and is available to the court in the present appeals. We then go on to say,
The judge below approached this, didn't he, on the basis that what you had purported to serve wasn't in truth a claim form at all because it wasn't sealed. So as far as he approached the case, it was what he thought is that your 310 application would circumvent or would be contrary to the sub-rule or sub-code, or you describe it as, in 7.6, and specifically 7.6.3.
yes,
So I mean, that's really the point.
and that is the point with which we take issue, yes.
So I understand you take issue with it, but the point about 615, in one sense, is a red herring.
It's
Because
an argument
that's
that's been
about
made
method of
against me
service.
that I
'Cause
needed
it
to
was either good service or bad service, and if it was bad service, then it's 7.6 which is going to save you, really. Unless the judge had said, which you could have said, I suppose, is it, well, I won't require further service in the circumstances, which is 616. But to describe what happened here as potentially falling in 615 seems to me to be slightly curious.
Well, my lord, it is an argument that was explicitly made against me by the respondents and by
Yeah, I
Mr. Kennelly, so it is incumbent upon me to
Yeah, I understand.
respond to it.
I don't-
But
I'm
you've had,
confused. I don't want to get into muddle. Correct me if I've got this wrong. I thought your clients below did apply to the judge under 650 for an order. 615 allows the court to say that the steps which had already
Yes.
been taken can be deemed effectively to be good service.
yes,
And I don't at the moment understand why that wouldn't have been a perfectly rational way of characterising what you were asking the court to do. You had done something, which was send an unsealed claim form, and one of the ways in which you were putting it below was, please exercise the power in 615(2) to say that the steps you'd already taken, which was to send an unsealed claim form, should be regarded as good service. That was something you were doing, isn't it?
yes. Well, my lord, the point, I'm sorry, again, I should, making this clear, we're saying that it does not, an in principle use of 310 in our appeals does not undermine or is not prohibited by, or as the judge put it, or Justice Dyson put it, in Steele, circumvent Rule 615, because in every other way we complied with the methods of service permitted under 6.3, except insofar as if the judge below.
Well, the argument that was run below was an argument that service of an unsealed claim form was service by a method which wasn't authorised by the rules, but was an alternative method that the court ought to
Yes, my lord.
sanction.
Sorry, all I'm saying is that we did not, like the cases in Barton and Peeperbrook, we did not fail to comply with or serve by a method that is not permitted, which then needed to be rectified because we complied with all the requirements of Practice Direction 6A.
Right, okay. Right.
But we rely primarily on the distinction drawn by Lord Justice Dyson in Steele, first between the distinction that I've already drawn to your Lord's attention, and also to the fact that what Lord Justice Dyson in Steele said in paragraphs 28 and 24 of his judgment is that what is problematic is applying Rule 310 to circumvent a prohibition contained in a sub-rule, or using 310 to achieve something that's prohibited under a subcode. And so we emphasise those, that aspect of Lord Justice Dyson's judgment. So we do say that, in principle, Rule 310 is available in these appeals. And we say that in all the circumstances, and weighing up all the relevant factors, this court should exercise its discretion under 310. And that, although I'm not sure that Mr. McAnally went quite this far this morning, but he went almost as far as saying that if prejudice is caused to defendants by denying them a limitation defence, or at least the ability to argue a limitation defence as regards some years of a claim, that's almost a trump card, and we say it's absolutely not. One needs to look at all the facts and weigh all the factors in balance when exercising discretion. Prejudice caused by the defendants, what that prejudice actually consists of, and you heard my submissions yesterday in that regard, whether there was prejudice to the defendants arising from the error itself, as in, did they know the case to be made against them? And we say they clearly did. Did they know a claim had been issued against them? They clearly did. Did they know what the claim was, yes, they had the particulars. And on the other hand, you do have to weigh against that the impact on the claimants if they are shut out from making the full ambit of a claim, the full ambit of their claims. Where again, I would ask the court to take into account the fact that the Supreme Court has said that at least as regards to a certain extent, there is a prima facie claim available to the claimants against the defendants, which you're being asked to a certain extent to deprive them of. So I'll just check my notes if I may, my lords, to see if there's anything, my lady, if there's anything else that I need to address. You'll be very pleased to hear that with 7 minutes to go, those are my submissions. I think Mr. Kennelly has a right to reply on the undertaking point. I'm not sure how long that's going to take.
Right.
My lords, I don't propose to go over any of the points on the undertaking. You have my submissions on it. And we heard from another friend is what she put in her skeleton argument. I'm obviously available for any questions that you have on that.
Unless you've got any questions. No, thank you very much. Well, thank you all very much indeed for your extremely cogent and helpful submissions. Obviously, we're going to reserve judgment. You will get a draft of the judgment in due course for any typographical errors to be pointed out to the court, not for re-arguing the cases you know. And if you could please endeavour to agree a formal order beforehand, we would urge you to do so. If for whatever reason you can't, then we'll deal with that by way of written submissions. But thank you all very much again to those behind you for the presentation of the case.
Court rise.